Good afternoon and welcome to today's edition of Trinity Talks, entitled Promises Made, A Guide to Warranties and Indemnities. I'm Jo Sykes, a Senior Associate in Trinity's London office, and I will be moderating today's session. I'm joined today by presenters Hugh Naylor, Head of Private Equity at Trinity, and Adekunmi Lawson, a Senior Associate in our London office. Today's session will take the form of a roughly 30-minute presentation, followed by a 15-minute Q&A. So please do share any questions you may have through the quick Q&A function in Microsoft Teams. And without further ado, I'd like to hand over to Hugh, who will be starting our presentation.
Thank you very much, Jo. It's good to be speaking to everyone this afternoon. As Jo said, I'm Head of Private Equity and I'll be helped by Adekunmi Lawson, a Senior Associate in the Corporate Department at Trinity. We've been lucky enough to have been instructed on a number of transactions in Africa involving warranties and indemnities, both in an M&A context and also in a more subscription or investment context as well. The aim of the talk today is really to just focus on a few high-level points, especially the distinction between warranties and indemnities and why one is more appropriate to another in certain circumstances. We're not going to do a kind of deep dive through a standard set of warranties. That would be fairly long. We wouldn't have enough time to do that, and it's probably the subject of a separate talk. So I'm going to turn on to the main slides, and I think the first sort of point about warranties and indemnities is why do you need them? What is the driver behind them? Lawyers spend an awful lot of time arguing not just about the warranties and indemnities, but also the matters ancillary to it. Things like limitations, repetition, disclosure, matters like that. So the starting point is why are these needed? So as a basic concept, when you buy a company or when you invest into a company, you buy it warts and all. The old Latin expression caveat emptor, the buyer beware. If what you thought was in the company wasn't there, if it doesn't hold the assets which it should have been holding, it has liabilities which you weren't aware of, those will affect you going forward. So essentially, warranties and indemnities are two common ways by which a purchaser can achieve suitable contractual protection when acquiring shares and assets. In other words, they underpin the substance of what you're buying. So if you buy a company and it has a contract with a third party, you want to know that that contract is genuinely with the company. It hasn't been misplaced. It isn't in somewhere in another entity. It hasn't been signed up to a different legal entity. Similarly, the assets, properties, machinery, vehicles, the like, should all be owned by the company. Or if not, you as a buyer are aware of that. So you're making a fully informed decision about the purchase price you're making. As I said, in drafting and negotiating sale and purchase agreements for assets and shares, an awful lot of time is spent on this. There are other ways of protecting purchasers, and some of those overlap with warranties, the cover provided by warranties and indemnities, and some cover slightly different nuances. For example, you can have completion accounts. That will be a set of accounts drawn up to verify the take-on balance sheet, the current position of the company you're acquiring, will hopefully underpin, again, if it's an asset-based deal, will underpin the value of the assets and liabilities. Other scenarios are to kind of almost metaphorically kick the can down the road by having an earn-out, where you pay a potentially fairly small upfront consideration, but then the consideration for the shares increases based on the performance of the business going forward. One of the logics being that it then means that if there are issues, historic issues, those will, to a greater or lesser extent, will come out during the earn-out period, with the result that hopefully that then gets reflected in the price. Other scenarios is a lot more hammer to crack a nut, is just simple price reductions. So there are deals you do when there are no warranties or indemnities, or extremely limited warranties or indemnities. The classic example of that would be something like an acquisition from an insolvency practitioner, from a receiver, where it's pretty pointless getting warranties indemnities, because the insolvency practitioner will simply distribute the consideration you pay and will not in any way take on any personal liability for the business it's selling. So that then normally just gets reflected in the price. And that type of transaction is a classic case of caveat emptor. You're paying, you've done your diligence in so far as you can, and you just buy on the basis of what you think the business is. Another kind of point to flag early on in the talk is that warranties and indemnities are not mutually exclusive. Subject to rules against not getting double recovery in respect to the same matter, you can bring both warranty and indemnity claims. Indeed, many purchasers will want an overlap between a warranty and indemnity so that they can choose under which claim they can make their claim. A good example of that is something like the interaction between a tax deed, which is essentially an indemnity, and the tax warranties. So I think if I could hand it over to Canby now.
Good afternoon, everyone. So what is a warranty? We ask the question as it sometimes gets confused with the lay term of what a warranty is. For example, in the lay term, if this laptop that I'm using breaks down whilst it's under warranty, I can get a replacement. Unfortunately, or fortunately, depending on which side you're on, this isn't the case regarding the purchase of shares or business. So simply put, a warranty is a contractual statement from the seller to the purchaser as to the condition of the target business or the company or certain aspects of it. You usually find these in the acquisition documents such as the share purchase agreement, the subscription agreement, or an asset purchase agreement. And in these documents, they're typically attached as separate schedules, which can run to a good few pages. So in answering the question of what a warranty is, I think it's worth mentioning what a warranty is not. And that is, it's not a promise about the future state or condition of the business. Typically, warranties are not forward-looking and do not impose future obligations on the warrantor. You can have separate provisions in the relevant agreement that do impose future obligations, such as condition subsequents or undertakings, but these would not be warranties in themselves. So now that we've discussed what a warranty is, the next question is, why do we have them? And at this point, it's worth stating that warranty claims are extremely rare. In mine and Hugh's many years of experience dealing with and drafting warranties in hundreds of acquisition documents, we've only come across a handful of warranty claims. So although on paper, a warranty can provide a form of retrospective price adjustment as they underpin the assumptions the purchaser has made in deciding to acquire the target, this isn't really the case in reality. In fact, what we see as the main purpose of a warranty is to be more process-driven, i.e. they encourage the seller to disclose information and issues so that they can be dealt with upfront before the parties are legally committed to the transaction. So on the next slide, we have set a few examples of the headings of what we typically expect to find in a warranty schedule. Although, and believe me, that warranties schedules do take a lot of thought, a lot of drafting, and a lot of negotiation, a warranty schedule can be relatively generic. This is because they typically cover similar ground. So in these that we have listed, you normally have a set of warranties underneath them. And these are sometimes divided into fundamental warranties and can be further divided into operational warranties and the like. So if a warranty schedule is relatively generic, then why are there negotiation sticking points? And why does it take days, sometimes weeks, to negotiate a warranty schedule? Every M&A lawyer has a story, a war story about how long it's taken to negotiate a warranty schedule. Well, this is mainly because there are nuances towards the target and the sector. As an example, there would be a different focus in respect of a heavy fuel oil plant in terms of the warranties given than there would be in relation to a fast-moving consumer goods transaction. Another key point would be in relation to the materiality qualification underlying the warranty. For example, if there's a warranty in relation to given consent, The debate is normally had on whether this is an absolute warranty, or if there's a minor consent missing and the company hasn't obtained it, this should affect the relevant warranties. It's worth saying that some counterparties do balk at any sort of materiality qualification. The argument being that if there are already limits and thresholds to warranties, as we'll discuss later, there should not be any additional qualifications in the warranties themselves. There's also some discussion about whether some warranties can be qualified by seller awareness. So if wording such as far as the seller is aware should apply. But there are typical examples of warranties that are not qualified by awareness, such as title and sometimes anti-bribery and corruption. Finally, it's sometimes requested by the seller that the seller gives warranties and makes full disclosures of anything relevant or any information that would be relevant towards a business. This is what we sometimes call sweeper warranties. These are normally hotly debated between the seller and the purchaser. When acting for a seller, we would ordinarily try and resist these sweeper warranties. The flip side being, of course, that when acting for purchasers, we would attempt to have them included in the transaction documents. So with that brief introduction of warranties, I'll pass it back on to Hugh to give you a brief introduction of what indemnities are.
Thanks, Cammy. So what is an indemnity? Essentially, at a very basic level, it's a promise by the sellers to reimburse the purchaser in respect of a particular liability, should that liability arise. In essence, the purchaser has identified an issue, it goes to price, it'll affect the value it wants to pay for the business, but the matter giving rise to that indemnity may or may not happen in the future. So one way of dealing with it would be simply just to knock the potential cost off the purchase price. But that obviously isn't particularly palatable to the seller, especially if the matter giving rise to the indemnity, it may be marginal, it may or may not happen. There may be an outstanding litigation, an outstanding liability. And so from the seller's perspective, he is better still retaining the full purchase price, but effectively promising to pay to the purchaser an amount equal to any liability if it ever comes home to roost, if it ever crystallizes. Typically, indemnities are very specific to individual issues. Like I said, it could be a historic dispute or a claim. It could be a environmental liability, a fine, something like that, something which hasn't crystallized yet, but is likely to. However, purchasers will push for generic indemnities just to cover, various matters which should be covered, which they feel go to price and should be the responsibility of the sellers, on the basis that these matters occurred during the seller's ownership period. Now, for generic indemnities, you already have the protection of the warranties. So take a case of litigation. You have a warranty that there is no litigation, and absent any disclosure to the contrary, if actually there was some litigation which was never made known to the purchaser, then the purchaser could sue under the warranties. But the purchaser sometimes will want to have an indemnity in that as well. But that's generic indemnities is generally rejected by sellers, and there needs, I think our experience is that you need to have a decent reason, and that could be down to the nature of the business, it could be for other reasons, but you generally need a good reason to be able to push for a generic indemnity. The one exception to that, however, is probably the tax covenant. So in a lot of transactions, you will have a tax indemnity, tax covenant, tax deed, call it what you may, and that essentially allocates responsibility for all historic tax liabilities to the seller, subject to certain exceptions, like, for instance, tax arising in an ordinary course of business. The reason you have a separate tax indemnity or covenant is manifold. It's to do with the different processes for agreeing tax claims, different timing of when tax becomes payable, dealing with things like loss of tax reliefs, which to a company can be just as debilitative to the cash flows of the company as an actual obligation to pay tax. So that's the reason. But again, that's an example probably of where you do get a relatively generic indemnity rather than something which just focuses on specific tax matter, a specific matter. Indemnities generally apply when the purchaser can't be protected through the warranties. So the classic case of this is where the seller and the purchaser have had a very open process. There's no information is being withheld, and the seller says, look, there is this warranty, there is this claim against us. We don't think it's got merits, but we're certainly not going to take a price reduction, but we accept the fact that you, the purchaser, do not want to carry the can for any liability should it come to pass. So in that case, there's a case for giving indemnity in order to protect the purchaser. And that probably leads on to another point, which is that indemnities in negotiating the transactions, the indemnity has probably come up later on in the transaction process than the warranties. So the warranties, you'll have a full set of warranties in the first draft of the agreement, and there'll probably just be a placeholder for indemnities. There may be something discovered in the due diligence process or the original IM where you want some protection, but generally a lot of indemnities come out of matters which are subsequently disclosed. So I think that's the indemnities. It's worth sort of focusing on the key differences between warranties and indemnities. Echoing what I said before, warranties typically support the generic due diligence exercise, and in certain cases allocate risk in respect of gaps in the due diligence and unknown issues. So you give a warranty which says that you have all consents, and you may even list those consents as well. And if there aren't any consents, then if a consent is missing, then that will give rise to a warranty claim. Indemnities are a lot more sort of laser-like, a lot more focused. And so they are predicated on the known liability, which has come out of the due diligence exercise. And so they're a lot more specific, they're a lot more tailored. One, I think warranties, I suppose, is best summed up in that warranties are, I suppose, they're a way of underpinning the information, while indemnities are much more about allocating risk. Echoing Canmy's comments, warranty claims are incredibly rare, certainly in my experience. Indemnity claims are a little bit more common, again, still pretty rare, but they're more common in that the basis is that the parties have agreed if X happens, then the consequence is that we pay you a certain amount. And actually, a number of times X does happen, and if the drafting is correct, then the seller will simply pay out because it's all been, it reflects a commercial deal. There's very little wiggle room, and so the seller has little moral or legal objection to settling the indemnity claim. This probably comes on to the two other key differences, which we're going to focus on. The first is the basis of damages, and then the second point is limitations of liability. Canmy's going to cover limitations of liability. So on the basis of damages, which I think is the next slide. So to have a successful warranty claim, you need to have the warranty needs to have been breached. So, obvious example, we give a warranty that all our contracts are valid, and it transpires that one of the contracts was terminated 2 weeks before completion. So that gives you a prima facie warranty. Then you need to ensure that none of the limitations apply. Now, those limitations are the very obvious one of disclosure. Taking my example, we didn't disclose that the contract had been terminated. But there's also other limitations as well concerning de minimis, claim thresholds, time limits, conduct of claims, was a provision made in the accounts, etc. All which are designed to give the sellers a degree of protection and avoid the kind of blank check approach where the buyer just turns around and goes, this warranty was breached, you know, pay me, I've settled with the other side and you owe me the difference. Then the second sort of key component of a successful claim is that there actually has been a consequence to the breach of warranty. It's reduced the value of the company or the business. So the company has suffered a loss or will suffer a loss, and a consequence of that is that the value of the shares has gone down. The shares you acquired have gone down. So a good example would be you give a warranty that you've got all consents, and in fact you're missing one consent, but that consent is, you can apply for it online. There's no consequence to you not having had it. It's more administrative than sort of liability based, and you can get the consent straight away. In other words, you can solve the problem. So, you know, there's a technical breach of warranty, but there's no loss involved, which kind of underpins one of the key sort of tenets of English law, that, you know, to have a claim for damages, you need to have suffered a loss. So the onus is very much on the purchaser to prove breach and to prove that it has suffered a quantifiable loss. Sometimes indemnities are given on an indemnity basis. That's where you have wording added which says that essentially the seller will indemnify the buyer of all losses arising out of the event giving rise to the claim. So there isn't then a necessity to tie it back to a reduction in the value of the shares. This is very standard in the US, but is rarer in the UK and Europe, and is usually a relatively well negotiated point on UK and European M&A. For a successful indemnity claim, this is a lot simpler. So all you need to prove is that the indemnity is breached, i.e., you know, we'll indemnify you for any costs arising out of fines levied by an environmental agency in the period prior to completion. So the fact that the environmental agency then levies a fine on the company for a historic breach is obvious evidence that the indemnity has been breached. And then recovery is simply on a dollar for dollar basis. All the purchaser has to do is show what the costs of that breach were, the expenditure it's incurred in relation to trying to resolve it, and any liabilities it's incurred. It doesn't need to prove a reduction in the value of the shares or the assets it acquired. It just needs to show that it has incurred expenditure. So this is probably one reason. This is one reason why purchasers seek indemnities, because there is a higher chance of making a successful claim and achieving a full recovery. And because of that, goes back to my comment that while warranty and indemnity claims are rare, indemnity claims are slightly less rare than warranty claims. One nuance which comes out of this much more binary approach to loss is that you always need to reflect the fact that with an indemnity, you're looking at the underlying loss suffered by the company. Now, if you're a purchaser and you've only brought 50% of the company, then obviously you shouldn't get 100% recovery for the indemnity, because your loss, in other words, the costs incurred by the company, is only 50%. Your loss is only 50% of the costs incurred by the company. So that's a kind of nuance to indemnity claims, which is important to keep sight of. And it's less important towards warranties, going back to the basis that your warranty claim is predicated on the value of the reduction of your shares. In my example, the 50%. So I think that is it's time for me to hand back to Cami.
So moving back onto the limitations of liability, I think it's been a common theme in this presentation that bringing a warranty claim is really quite difficult in reality. And one of the reasons for this is because it's typical to have certain limitations to any claim that a purchaser may have in regards to warranties. Again, limitations can be included as a separate schedule to the SPA, but here we've just listed a few just by way of example. The first one we've listed is in relation to qualification by disclosure. Warranties can be qualified by disclosure against them, but indemnities typically are not. The definition of disclosure is one that will be considered carefully by the parties as to what actually constitute disclosures. And the disclosure is typically made by way of a disclosure letter. A disclosure letter will have two parts to it. There's a front end being general disclosures, for example, matters in the public domain or matters on public registers. And the purchaser will be treated as being aware of these disclosures. And there is also the back end of the disclosure letter, which are specific disclosures against specific warranties. And what disclosures can lead to are either price adjustments, or a disclosure against a warranty can lead to an indemnity, as Hugh has covered, or in the worst case scenario, the purchaser may just refuse to go ahead with the transaction as the disclosures are made before the agreements are entered into. The next limitation that we've listed, and I'll just rattle through these quite quickly, is in relation to the overall claims caps. Again, these can apply to both warranties and also to indemnities, and as a result, the sellers will not have any will not have an unlimited liabilities with respect to a warranty or an indemnity claim. The level normally differs from transaction to transaction. We're normally asked what is market standards in these, but these are differ, as I say, from transaction to transaction, and it can be up to the level of the consideration received by the purchaser or a percentage thereof. Moving on to time limits on warranty claims. In the spirit of not having unlimited liabilities, warranties are also typically limited by time, and indemnities can be as well. In more recent times, we've seen these time limits being linked to the review periods of the purchaser, i.e. how many audits or reviews of the company the purchaser will have and will be able to undertake while the warranty is still live. Normally, we see this anywhere between 1 and 2 reviews, so typically 18 months to up to 2 years in relation to ordinary warranties. Tax warranties are treated differently in this regard, and the period given is normally 7 years, because this is typically the period in which a revenue authority is able to go back and review the filings made and make a claim. There's also normally a difference in the time limits given between fundamental warranties and other warranties, and we can sometimes find fundamental warranties to be unlimited in relation to time. Moving on to awareness, there are typically 2 types of awareness to deal with. One, purchaser awareness, and the second, seller awareness. This is again linked to disclosure. With indemnities, the purchaser awareness is of course irrelevant. In fact, the purpose of the indemnity, as Hugh has said, is to protect against a situation that is already known. Awareness qualifications, such as so far as the seller is aware, are often included in underlying warranties and sometimes can be included as a blanket limitation to the warranties, thereby limiting the warranty to the awareness. Broadly, the purchaser awareness, even if matters are not disclosed, acts as a bar to bringing a warranty claim. So at the end of this slide, we've just listed separate other limitations. For example, diminished limitations, baskets and thresholds. These would be hotly negotiated between the counterparties to the relevant agreements. We've also stated the duty to mitigate loss, which is a common law duty under English law, but is also typically included in contracts as well. Hugh has already covered the directness of damages and foreseeability. And also limits can be included in relation to provisioning in the accounts. The final point to make is that if you have different avenues of recovery under a document, you normally state in the document that double recovery is not possible. For example, you will not be able to make the same claim for the same loss under an indemnity or under a warranty. So this covers our brief introduction into warranties and indemnities. And now we have opened the floor for any questions and answers.
Thank you very much to both Hugh and to Conmy for that presentation. Certainly as a finance lawyer, I found it very informative, so thank you for that. We've received a number of great questions during the course of the presentation. So perhaps I could ask the first one to Conmy. And let me just put you on the screen. So Conmy, we've been asked, is it typical to qualify all the warranties as being subject to awareness, or is this usually covered on a warranty by warranty basis?
Thanks, Joe. That's a very good question. And as I said earlier, I think we have to distinguish between the purchaser awareness and the seller awareness. Regarding the purchaser awareness, it will normally be pushed by the purchaser to limit everything to have a blanket limitation on awareness, but this will ordinarily not be accepted by the seller. So what we typically find more usually is to do it on a warranty by warranty basis, because there are some warranties that should be more prone towards awareness, such as disputes between third parties that you're not a party to. And there are other warranties which you should have absolute knowledge of, and therefore should not be limited to awareness. So we, as a balanced draft, would normally say that it should be done on a warranty to warranty basis.
Great, thank you for that. And perhaps while we've got you on the screen, just one other question for you, Conmy. Somebody has asked, in terms of representations and warranties, what is the difference between a representation and a warranty? And does it matter what that difference is?
That's another good question, Joe, because in drafts you will see representations and warranties, and often it's actually not correct to list both representation and warranties. The key difference is in relation to the remedies, and what remedies that you can get from a breach of warranty and what remedies you can get from a breach of representation. For a breach of representation, one of the remedies that you can get is a misrepresentation, which would lead to a rescission of the contract. But this would not be the case under a breach of a warranty. Hugh covered the breaches and the basis of damages that you would get under a warranty. What we tend to find more recently in the market is that we don't have sellers representing and warranting, whereas this was quite usual probably about 10 years ago. But now it's more of a case, especially in transactions in Africa and obviously UK law transactions, that we just have warranties as opposed to warranties and representation.
Great, thank you very much. Perhaps turning to Hugh, we've got a question here. If I'm concerned about past liabilities, can I not simply, ask the seller to give me a blanket indemnity for all pre-completion liabilities?
Yeah, it'd be nice to be able to get that, and as a purchaser, that would be the absolute sort of holy grail of contractual protection. A seller's going to be very, very reluctant to ever give that, just because by its very nature there are historic liabilities which just incurred in the ordinary course of trading, which just apply, and it's part of buying a business. Technically. If you have you buy into a company, there will be a residual liability to maybe pay a bonus to an employee or something like that, and that's all part of the business going forward. So it's very hard for a seller to give, and I think a buyer to ask for that needs to be in a very strong position, or there needs to be something about the deal. It could be a low value deal where there's just, the buyer is taking a huge, is potentially just very concerned about liabilities. Sometimes, and I suppose in the converse, in a high value deal, the buyer is in a better position to negotiate that. But it's certainly not something I've ever seen, apart from a couple of sort of smallish deals with a very hard-pressed seller, where the seller really had nowhere to go, and it was a question of selling on the basis of a full indemnity or the deal not happening. And I think the seller was fairly, had a good idea of what those liabilities were. But yeah, it would be nice to have as a purchaser, but it'd be very hard to. I think it would be a hard one to justify in most transactions.
Okay, so I think that leads us neatly actually onto our final question, which is whether you could perhaps provide some examples of indemnities that you have seen on recent deals, given obviously we're saying the blanket indemnity is certainly not something that's common. Perhaps just some examples of things that you have seen recently.
Yeah, so a good example recently would be a litigation matter where which is a sort of it's a very typical example of an indemnity where there's ongoing litigation. Commercially, the parties agreed that the sellers would retain conduct of that, so they would still manage the litigation and the dispute resolution process, albeit through the auspices of the company. But part of that was that if the company suffered any losses, if it ultimately lost the claim, or was out of pocket through legal fees, having to pay for the other side's legal fees, whatever, that the seller would effectively carry the can for that and would indemnify, or essentially would indemnify the company to ensure that the company wasn't out of pocket. We've had claims, some fairly specific tax based indemnities, where a generic tax indemnity itself hasn't applied, but the parties have agreed that specific tax issues should remain with the seller. And again, in the case I'm thinking of, that was where there'd been quite a substantial pre-sale reorganization before the transaction happened. I think it was 6 to 9 months beforehand, which was carried out properly, but the sale potentially triggered tax liabilities in relation to that historic event. So again, the approach is that the seller would have conduct, subject to some fairly standard caveats, but if the tax ruling went the wrong way, then that was for the seller's account, not the company's. So those are probably the two sort of most recent examples I've experienced.
Brilliant, thank you very much. So I think that's all we have time for today in terms of the Q&A. I'd like to extend my thanks again to both Hugh and to Conmi for the presentation. And just to let everyone know about our upcoming Trinity Talks, you can find a list of all of these on our website, together with videos of all previous talks, which are available through YouTube. And without further ado, I'd like to say thank you very much to everyone for listening. We do hope you can join us again next week, and goodbye.